Did you give them my details?
Because you've given me your details.
Right, that's against the law. It's a breach of my personal data. You should not have done that. You have not. You should not have done that.
You've handed over the coins as tender.
Yep.
Obviously, it is legal tender. You are correct.
Yep.
But as Sainsbury's, we aren't obliged to take that because we aren't able to bank that here. So unfortunately, we will have to ask for some other means of payment to purchase that fuel.
What do you think legal tender actually means?
Pardon?
What do you think legal tender means?
I'm not into a debate about that. We're not accepting that as a tender here. It's a private company.
So you accept it as legal tender?
Yeah, but we can't bank that here. We don't have the means to bank it, so we don't accept it.
That's not my problem if you can't bank it, is it?
Well, yeah, but we don't accept it.
Well, you already have.
No, we haven't. You just put it down.
No, I gave it to the lady and she put it in her hand.
So, have you got any other means of payment?
That is my means of payment.
So, have you not got any other means?
But that is my means of payment.
Well, and we can't accept that means.
Brett points out the crucial moment when the employee physically took the coins into her hand. The instant she accepted them, the outstanding balance was settled. The payment had been completed. It's true that a retailer can decline Royal Mint coins if that rule is clearly stated before any transaction takes place. However, that wasn't the case here. The petrol had already been pumped. The product had been used, which automatically created a debt. Once a debt exists, legal tender must be accepted. You cannot take lawful money into your possession and then dismiss it simply because handling it is inconvenient. This is where Sainsbury's and later the attending officer made their mistake. They mixed up personal convenience with the actual law.
Another means of payment, or do we just need to process it as a civil recovery issue?
Well, I paid.
Well, we haven't accepted it.
You don't need to. Well, you have accepted it.
We haven't.
Well, I haven't got the money, have I? You've got the money.
Well, we can give it back to you.
Well, I don't want it back. Are you a police officer?
Yes.
Right, can you identify yourself, please? What number are you?
1866, Bridgewater Police Station.
Mrs. Bradshaw, Miss Bradshaw.
That's correct. Miss.
Miss.
Sorry.
Sorry.
So they've asked for another form of payment
Yeah.
because they can't accept this form. Have you got another form of payment on you?
That is my payment.
Right, okay, but that's not tender that they can accept.
Yes, it is.
They're asking for another form
Yes,
of
it
payment.
is. Let me explain something to you. So when you was training to be a police officer at the beginning, yeah, you swore an oath, didn't you?
Yeah.
Yeah. Do you remember what the first sentence of the oath was? It was to serve the Queen faithfully.
Correct.
Right. Now those coins are legal tender by royal proclamation of the Queen herself.
Okay.
Right. She's authorised within the legislation for the Royal Mint to create those coins, and when she proclaimed them to be legal tender, she said that they are legal tender for payment throughout the United Kingdom.
When the officer arrived, she repeated what the store employees told her, treating shop policy as though it outweighed legislation. Brett immediately challenged that reasoning by reminding her of the oath she took upon joining the police, promising to uphold the crown. That detail matters. These coins were not random pieces of metal. They were officially recognized as legal tender through a royal proclamation under Section 2 of the Coinage Act 1971. In the UK, it is the Crown, acting through the Royal Mint, that determines what qualifies as legal tender. Brett wasn't expressing a personal view, he was referring to the very legal authority she had sworn to support. By connecting her oath to that proclamation, he highlighted how flawed her position really was.
They've allowed me to take goods, and then pay after the event. When the fuel goes into my vehicle, it becomes my fuel, but then it becomes a debt. Okay, now, the whole point of legal tender is that you can use it to pay a debt. As the Queen said, it's for payment throughout the United Kingdom. Okay. So they don't have to accept it, and if they was to give it back to me, it would negate the debt. Mm-hmm. Okay, it's not a police matter, it's a civil dispute. So really, you know, I mean, really, you should be telling them that it's a civil dispute.
I've just spoken to them and said about the document whereby you can come back and pay within 24 hours. They're saying that they don't want to accept the tender that you've given them. Is there an alternative method?
I'm not going to pay it any other way. I've already paid. Okay, and regarding that document, it's called a no means to pay document, isn't it? Right, I'm not filling out a no means to pay document when I have got the means to pay and I've paid. It's almost like an acceptance that I haven't got the means to pay when I have.
The officer then attempted to push a no means to pay form onto Brett. That document is typically used when someone genuinely cannot pay at the time, such as forgetting a wallet, having a card declined, or possessing no money at all. In those cases, the person acknowledges the debt and agrees to return later to clear it. It exists specifically for situations where there is truly no method of payment available, but that wasn't true here. Brett did have a way to pay who was holding legal tender issued by the Royal Mint. That fact alone removes this situation from the no means to pay category. By trying to make him complete the form, both the officer and Sainsbury's were effectively ignoring the reality that valid payment had been offered, simply because they did not want to accept it.
May I take your name, please?
No. Oh, yes you will, because I'm driving.
Sorry?
Yes you can, because I'm driving. Sorry. There you go. Although technically, parked up on private land. I'll be going soon, as soon as I finish dealing with it.
Is that the money?
No, I don't want that. If you give it back, then it goes to debt. Did you see that, officer? Officer?
Yes,
I've paid and she's thrown the money back in.
They've asked for another form of
No,
payment.
she's thrown the money back in.
Okay.
Do you understand? Can you explain to them that that negates the debt? You can't pay someone and then they just throw the money back at you.
Do the paperwork.
Do you want to remind them of that?
There we are. So that's the details of the transaction, sir, okay?
Ma'am, can you show it to me? I paid it though.
Yeah, but it's unacceptable tender.
Officer, did you witness them give me the coins back, didn't you? When I have paid, yeah?
I've witnessed them give you the coins back. I've also witnessed them say that it's unacceptable tender. They're not willing to accept it. Therefore, they've asked for another form of payment. You haven't provided it, so that's hence why they're giving you the form.
Well, I don't want that.
When the officer asked Brett for his name while he was seated in his vehicle, he was legally required to provide it. Under the Road Traffic Act 1988, a driver on a road or public place must give their name and address when requested by a uniformed constable. That obligation applies regardless of why the officer is there. So at that moment, since Brett was behind the wheel, compliance was mandatory. However, what happened next raises serious questions. Shortly afterward, a store employee returned with a no means to pay form that already contained Brett's personal details. Brett had neither signed nor agreed to that document, and he had clearly stated he was paying with legal tender, which leads to the obvious question. How did they obtain his information?
Can you give these coins back to her, or can you keep them as evidence?
I'm not giving the coins back.
Well, you do realise it negates the debt anyway.
They haven't accepted
I don't want that either, and that's nothing to do with me. I would like a receipt though, please.
You've been
I
served
can't
with
give you
it.
a receipt. The transaction's still outstanding, I'm afraid.
Do they have to give me a receipt for VAT purposes?
You haven't paid for
I
it
have
because
paid.
they haven't accepted for tender.
I have paid. They had it in their hand. They threw it back in the car.
Okay, but they
You
haven't
witnessed they
accepted,
threw it
they
back
haven't
in.
accepted for tender, so therefore there isn't a
So
payment.
it's for, as I said to you earlier, the Queen said
I
that these,
understand what you're saying,
Yeah.
and you've obviously done your research.
yeah.
What they're saying is it's not acceptable form of tender. They're not accepting it, therefore the debt hasn't been paid.
But you're an
hence
officer of the
why-
law, aren't you? You're a sergeant or just a PC?
PC. Hence
Yeah.
why they've given you this, because they want you to pay in another acceptable form of tender.
So what do you think, if they said that they didn't want to accept a £50 note and threw the £50 notes back in, yeah, and then gave me that, would you think that's reasonable?
Well, you
Or £20
have to offer
notes.
another.
Brett then flipped the argument with a simple comparison. If someone hands over a £50 note and the shop throws it back, then insists they complete a no means to pay form, most people would see that as unreasonable. The principle here is no different. Once legal tender is presented, the debt is cleared. If it is refused, that is not the customer's failure, it is the store's. Yet the officer continued to repeat that Brett should provide an alternative payment method. That position reflects preference, not law. By choosing convenience over legality, she transformed what should have been a resolved matter into a dispute treated as though it were criminal. At that point, her argument lost its foundation.
So say I had 50s and £20 notes, okay, and I went in there to pay them, and they said, "Oh, sorry, we don't accept those," right? Yeah, but even though this is theoretical, yeah, we don't accept those, and I say, "Well, I've paid, and I've left the money on the counter," and they came in and threw them back in the car. Would you still be saying that it's up to me to pay in some other way?
But they just said that's an acceptable form of tender.
Yeah, but it's not down to them as to whether it's acceptable or not. It's down to the state.
They don't deem that acceptable.
It's down to the state. It's not for them to
right.
choose.
Well, they've served you with this. They haven't accepted payment.
I don't want that. That's nothing to do with me.
Right, okay, well, you've seen it. She's showing you it.
Yep.
Okay?
I don't know what it is. I don't even know what it is. What is it?
It's
I haven't
because
signed any. What is it? No means to pay form or something like that. How did they get my details? Did you give them my details?
Because you've given me your details.
Right, that's against the law. It's a breach of my personal data. You should not have
You
done
haven't
that.
paid.
You have not. You should not
haven't
have done that.
You haven't paid.
You know that. You should not have done that.
When the officer displayed the no means to pay document, Brett immediately noticed something alarming. His name was already written on it. He questioned her directly about how the store had obtained his details. She acknowledged that she had provided the information, reasoning that it was acceptable since he had already given it to her. This presents a serious data protection issue. The officer collected Brett's personal information under the authority of the Road Traffic Act, which limits its use strictly to road traffic matters. Sharing that data with a private supermarket in what was essentially a civil disagreement goes beyond those limits. Police officers are obligated to protect personal information, not distribute it to businesses for their convenience. Instead of addressing that concern, the officer maintained that he had not paid. This reflects a misuse of police authority, prioritizing a company's interests while disregarding individual rights and data protection obligations.
I'll be lodging a complaint about this.
Okay,
You know you're going to be in trouble for that, don't you? No.
You're not.
You know that you're going to be in trouble for that, don't you? Because you're not allowed to give them my personal details. Breach of my data. Police giving private corporation my details. They threw the money back in the car. We'll be lodging a complaint with 101, I think, straight away.
In a later update, Brett explained how his complaint was handled, and the response was surprising. The police concluded that the officer had acted appropriately, effectively supporting conduct that allowed a private company to reject legal tender, return it to a customer, and use police powers to access personal data under the Road Traffic Act. It goes beyond a simple misunderstanding. It blurs the boundary between public authority and corporate preference. Brett pointed out that by obtaining his information through police involvement, the store was able to complete a no means to pay form without his agreement, creating the appearance of a contract he never accepted. That is the core issue. Although his solicitor advised that he may have grounds to pursue the matter, taking it to court was not considered worthwhile. Even so, the outcome was telling. An inspector later confirmed that the officer would undergo retraining, which speaks volumes. When retraining follows an encounter like this, it suggests errors were made.